There are every year almost about 150,000 marriages and 50,000 divorces. And in every divorce cases, the judge, if there are children, needs to decide on the custody. There are 58% custody, joint custody, and only 4% when the court decides on behalf of a man, and 37% for custody for a woman. If we think about custody as joint custody as the best for the children, I believe that 58% is not enough. It should be 90%, because I think that the custody for one parent should be only in such situation when it is not possible, really not possible, to communicate and to take a part in a children's life. If the court decides on a shared custody, then after 2-3 years, the parents see that this was a good decision, because they are forced to communicate and they put aside the issues that they thought are going to be very difficult to deal with at the beginning. Sometimes we see during the litigation process that when the court tells the parties to do so, their attitude to shared custody is changing. So I believe that this is the solution, but the problem is that the courts do not use it. The problem is that we use in a society when it says that the woman is the one who should have the child, and then when we've got a divorce or separation, the court, and in courts we've got women who are judging, especially because I believe more than 90% of judges in family cases are women, and then decide on behalf of women. So I believe that the problem is in the attitude and in the fact that there are no forcible measures if this alienation is the problem. The process is very long, and after a few years sometimes of such a process, it's not possible to rebuild the relation between the alienated father and his children. So this is one of the problems, and the other is that so far alienation was not a criminal case problem, because we've got just first sentence in Poland when a court sentenced mother for violation on father by alienating him from his children. When the father is alienating, the police is more eager to help the mother to physically take children to fulfill the obligations of the sentence. But in Poland, if the court decides on divorce, it must decide on the guilty, which party is guilty of the divorce. And if there is no conflict and the parties are able to communicate and finish the divorce case quickly, there is no long-term court case during which they are fighting for this fault. Sometimes we fight in court for many years, and those are the years during which the children are in the middle of the battle of their parents, so they are manipulated by one of them or both of them. And then after the whole process, the children are unable to have the normal relationship with the parent who was the bad one. Because where there is no conflict, then they can say the court not to decide on the guilty. But if one of the parties wants that the court give the settlement on the guilty, so the court must take the whole process of getting evidence on who is really guilty of this resolution of this marriage. In district courts, there is a problem with the knowledge, but the the judges have more time for the process. They are concerning only on this issue of children. Divorce, which is in higher court in Poland, then the judge decides on the guilty case, and the problem of custody is just one of the issues that needs to be settled in the verdicts. Also, there's a problem that the judges do not understand the shared custody. For them, it's the problem, because if parents say that they cannot communicate, judges decide not to give them shared custody, and sometimes it's just a decision made for the court. Our legal system is also changing. I believe that the judges are still doing as they used to do. Mediation has a significant role in family cases, and I believe it's very important. Parties can learn how to communicate with each other. They need to communicate during the mediation process, and what is more, they can take into account many more issues than it is possible in the court. It is a good way to start communicating and solving the problems that are before going to court, because as they go to court, it's sometimes too late for the children, for relations, etc. There are national marriages and marriages who are living abroad, and one of the parents is deciding to get back to Poland. And we've got a lot such cases, so I think it's a huge problem. It's a huge problem for children, because they used to live for a few years in another country. But I think that the Hague Convention, which allows the parent to take back the children, is also the legal measure that is used, and that in such cases the child interest is taken into account as the most important. From my experience, such proceedings, when one parent without agreement takes the children to another country without the consent of the parent, are very quickly verdicted. Decisions for the benefit of the parent where the children used to live and where they have their center. So I think that this is quite a good resolution for such situation. For children, it's not good to have their center of life in two countries, because it's even not possible to go to school or to make friends. So in such a situation, joint custody wouldn't be the best way of custody from the point of view of the child. The problem is that professionals, judges are not trained on family issues, on mediation, and on shared custody. They do as they used to do. So if they know, they don't know new trends, they don't know the psychological issues concerning from shared or sole custody, and if they're not trained, if they do not know what's changing in the attitude to this kind of custody, they make decisions on their own experience. The best way of custody is shared custody, and then the court needs to take it into account. Before someone decides to go to court, he or she should think about mediation, because it's a really great process, and even if they do not get a satisfying settlement, they will get the clue for communicating. So I believe in mediation.